All right, I would like to welcome all of you here. My name is Phil Weiser. I've got the pleasure of being the Executive Director of the Silicon Flatiron Center for Law, Technology, Entrepreneurship. How many people here is their first time at a Silicon Flatiron's event? Okay, how many people have been here 5 or more times? How many 10 or more times? All right, welcome to our newbies who haven't been here before. A few overall marks to keep in mind. We very much are engaged around our students, so we'll have a tradition of the first question going to the students. Please don't take that personally if you're not one. If you are a student and you've not taken copyright law, today will inspire you to do so. We have an extraordinary asset here at Colorado Law. Her name is Cristelia Garcia. Yeah, let's give it up for Cristelia. As some of you may know, I was the dean of the law school, and I don't think there's anything that we will look back upon me doing as dean that will rival the hiring of Cristelia to our faculty. She's an extraordinary teacher, scholar, and human being, and what she brings to Silicon Flatirons is very much in line with our essence, which is looking at issues with a level of depth and rigor, which are not, if you will, prejudiced towards one perspective. As she looks at copyright issues, insofar as she has a perspective, she starts from what does this mean for artists? And she has brought a new dimension to conferences here by bringing artists like Aloe Black, who we'll hear from, DJ Spooky and others, to the table to talk about how law and policy issues affect them in the creative industries. It's been an exciting set of conferences. This is the third one she's doing, and we look forward to many more. In her mind, and I'm not sure I can agree with this because I found the first two so stimulating, this may be the most interesting and important topic yet. And for those who are not following this, this case is now on appeal right now as we speak. Yes, and we'll hear a little bit about that. We have someone who's been very involved. We'll start off with a keynote address. Not very often do you get a case that has this much of a profound influence and then get to bring people together to make sense of it. We are thrilled to be a part of that Silicon Flatirons. This work does not happen easily, although I can't take credit, contrary to Bob's suggestion, to playing Marvin Gaye in the cafe. That was an added bonus. Not quite sure where that came from. But I can say we've hired a great team, starting with Anna Noskese sitting over here, Kelly Brown, Sean Diamond, Susanna Weller, and Sarah Schnicker. Can we give them all a hand of applause? They're truly extraordinary and have been phenomenal to work with. If you look at the back, you'll see what's next on our calendar, and we have two final public events. One is the New Venture Challenge Championship, which is really trying to get people together from different disciplines while in school, working on a problem, solving it, and may well creating a company out of it. It's often magic, exciting. Consider joining us. And then our final crash course, Creating a Great Company Culture, will be another fabulous event. For those not familiar with our entrepreneurship initiative, Brad Bernthal in the green shirt over there is the guy to talk to. It's been an exciting journey. That's been now going on for about 10 years. Our content initiative with Cristelia is going on, finishing up its third year. Without any further ado, let me introduce the aforementioned Cristelia Garcia.
Thank you all so much for being here today. I want to echo a lot of the people that Phil already thanked. Obviously, Anna Noskese, our fearless director, and her team, Sean Diamond, Susanna Weller, and the countless other persons, both behind the scenes and here on the scene, who really make this possible. Kelly Brown for tireless marketing support and really helping us kick it up a notch this year. Sean Belcher, and the entire Colorado Law Technology Journal team for their enthusiasm and support of the conference. Sarah Schnittgren and the Silicon Flatiron Student Group, and especially Courtney Mirage for the wonderful primer that they put together. countless students and colleagues who did everything from run to the airport repeatedly to grab people to offering babysitting to get this done. Thank you also to the Colorado Bar Entertainment and Sports Law section for their marketing support. And of course to all of our panelists and our presenters who flew in from all over the country with lots of other things going on. And welcome to everyone out there who's joining us by live stream. We have a really great lineup today, and I think we're all in for a treat. As Professor Weiser also said, if you find, are a student and you're finding some of the things we talk about today interesting, and you're not already taking copyright with me and here by force, you should consider taking copyright with me in the future so that you can be forced to attend such a conference. I'll start off with really brief introductions because we've got so much to dig into with Richard today. I am an associate professor in my third year here at Colorado Law. Teach intellectual property courses like copyright, trademark. I also teach first-year property, and my research really focuses on copyright, in particular the economics of the entertainment industry. So this particular theme this year is near and dear to my heart. I formerly worked in the music industry, first in-house at MySpace Music and then with Universal Music Group, where I worked on digital licensing predominantly. And prior to that, I practiced law, believe it or not, in New York at Wachtell Lipton and then in Los Angeles for a few years with Quinn Emanuel, who Richard knows well. Yes, Richard, who joins me today, is a partner at King & Ballow in Nashville, where he heads up their entertainment and intellectual property department. He earned his JD from Loyola University Law School, and he clerked for Chief Judge Parker in the U.S. District Court for the Middle District of Louisiana. He is, to say the least, a renowned copyright litigator and has been involved in I'd say the majority of the most impactful and important copyright decisions of the last couple of decades, some of which we'll get into here in a moment. And it's a real honor to have him with us today. With regard to the featured case that we're focusing on today, Williams versus Bridgeport, Richard achieved a landmark verdict for his clients, two of Marvin Gaye's children, and sent shockwaves through the music community with a holding that has significantly or potentially significantly broadened the doctrine of substantial similarity, as we'll discuss today. So I want to start, as some of the students in here know, but some of the other folks may not be as familiar with some of the big cases that you've done leading up to Blurred Lines, many of which could easily be called game changers. And there's quite a few to choose from, so I've highlighted a couple here that I'm particularly interested in. One case which needs very little introduction, at least for students of copyright, is Bridgeport versus Dimension Films, in which we had the Sixth Circuit basically set up a per se finding of infringement for sampling. In other words, it declined a de minimis defense for sampling. And I wanted to ask you how that case came about. Who approached you? Like, how did we even get to where this was getting into court?
Okay, so that is a question that has a lot of background to it. And I think some background, a lot of you people here today are law students. Is that right? And I think a lot of you in law school want to know how you get to be maybe sitting here right now at some point in your careers and have won big cases. And I think this is somewhat motivating, so I'd like to back up and indulge me for a few minutes, and I'll answer that question with a little bit of a story. So I joined my law firm in 1991. In 1993, we represented the New York Daily News newspaper in New York. There was a big strike at the New York Daily News newspaper, and the mafia basically runs the unions at the New York Daily News. And they got everybody who worked at the New York Daily News to file fraudulent workers' compensation claims alleging they all got deaf working in the noisy newsroom, in the press room, although many that filed the claims were drivers and had never stepped foot in the press room. So the Tribune Company was self-insured. They owned the New York Daily News, and they paid out millions of dollars in these claims. There were millions of dollars in claims remaining when they called us up and said, what's going on in New York? So I'm a first-year associate, I'm second year, and I'm myself and the senior partner go to New York, and I'm supposed to be there for a week, and we investigate the case, and I decide, I'm left behind for like a week, and I decide it's all fraud. Because these idiots, when you work in a newspaper, OSHA requires you to take hearing tests every 6 months. So 6 months earlier, they had perfect hearing, and now they're stone deaf. So it wasn't that easy, but it was kind of, the evidence was there. So I recommended that we file a 600-defendant racketeering case under civil RICO against everybody. The doctors, the lawyers, the unions, everybody that filed the claim. So I'll never forget that I called the senior partner up. Now, I've been out of law school for a year and a half. I called the senior partner up and said, I think we should do this. And I had gone to the County Lawyers Association in New York and had studied all the RICO cases. I read them all. I knew nothing about RICO. And I said, well, I think we got a case here. So I remember him saying, Richard, we're going to do what you say, but you better be right. And so I said, I think I'm right. And so we went to Wachtell Lipton, actually, to be co-counsel, and they didn't kind of see the case. And so then we went to Sidley Austin, and Sidley and Austin was my co-counsel because the Tribune Company is not going to trust a case like that to a first-year associate, you know. So, but it was my case. And I moved to New York, and I lived there for 5 years prosecuting this civil RICO case. And from the moment I got there to the time we were done, we got all our money back, and we didn't pay out another penny. On my last day in New York, very last, I've told this story many times, but on my last day in New York, I'm waiting for a taxi outside my building. We'd settled the case. And there's a guy standing next to me. And we're waiting and we're waiting. It's a cold day in January in New York. And finally I say to him, hey, a cab's not going to come. And when one comes, let's share it because we're both going in the same direction. He says, fine. So we get in the cab. He asks me what I'm doing in New York. And I tell him my story, just like I told it to you all in 30 seconds. And I said, well, now it's over. I'm going back to Nashville. I know what I'm going to do. And he says, well, my wife's in the music business. We go to Nashville from time to time. And maybe give me your card. And maybe if we go to Nashville, we'll call you up. We'll have dinner. So I searched. I never carry a card with me. I have one card. I give it to him. Get out of the cab. I expect nothing. Now I'm back in Nashville. And I'm like, what am I doing with my life? I have this great experience, but I have no clients because I've been on this one case for 5 years. So I've got no clients. I've got nothing. And I'm just like transported back to Nashville when one day, a few months later, the phone rings. Hey, remember me? We shared a taxi cab in New York. And I'm in Nashville. And my wife's with me. You want to have dinner? Sure. We have dinner. Who's his wife? The copyright administrator for Bridgeport Music and Westbound Records. Who's Bridgeport Music and Westbound Records? They own the funk music of the Ohio Players and George Clinton and Parliament Funkadelic. And she tells me they've identified 500 different songs that sample other songs. And they're getting ready to launch this massive copyright infringement litigation. And you know what? You handled this big case in New York. And Nashville seems like a good place to do something like this because it's cheaper than New York or Los Angeles. And you know what? He has lawyers. The owner of Bridgeport has lawyers in New York and Los Angeles. But maybe if you go to Detroit and meet him, maybe he'll like you and hire you. And I said, well, I don't know anything about copyright law. I don't know anything about music law. I don't know anything about anything. She goes, oh, you can learn it. She said, you did this big case. You can do it. So off to Detroit I go. I meet Armin Baladian, the owner of Bridgeport Music. He likes me. He hires me. 6 months later to a year later, we file what is now world-famous litigation, the Bridgeport Music litigation involving 485 cases of copyright infringement against the entire rap music industry. So the short story is that had I never shared a taxi cab with this guy on my last day in New York, and there's more to the story that I'll tell you, I would not be sitting here right now, today, in the last 18 years of my life would not have happened. So we filed that case, and obviously it sends shockwaves through the entire music industry. And I remember sitting in the federal courtroom in Nashville with every entertainment lawyer in the United States representing some defendant in there for our initial case management conference, and just me. And I'm sitting there, and it's everybody from every major law firm you can imagine. And I'll never forget this because this is one of the cases we'll talk about. Somebody gets up there, and he's a friend of mine, Jeff Golden. He represents Universal in copyright litigation. He says, these cases are idiotic, Judge. Let me give you an example. In one case, Bridgeport Music is actually filing a lawsuit claiming ownership of the word dog. They're saying that because the word dog was used in a song, there's copyright infringement. How idiotic is that? Well, 6 years later, Jeff and I had the pleasure of litigating that case, and I won it.
Pleasure.
And I won that case, which is ironic.
For my students, that's the atomic dog case and the panting that we listened to on last week.
And we'll talk about that. But how did the Dimension Films case arise? So how did that become first? Well, what the judge did was he severed all cases into 476 separate cases, and he said, we're going to do the first 10, and we'll see what happens after the first 10. And the Dimension Films case, in number, was 1. And what happened next was we were summoned to Universal's headquarters in Los Angeles. It was the general counsel of Universal at that time, and it was his entire legal team, Mitchell Silverberg. Must have been 9 different lawyers there sitting around surrounding him. And it was me and Armin Baladian, the 75-year-old guy, and just me sitting there. And I'm this young kid, and I'll never forget the general counsel said to me, your cases are frivolous, but I'm going to do you a favor. If you dismiss every single one of your cases today, we will not seek attorney's fees, and we won't end up owning his catalog. And I said, and he said, look at this team that's around me. You're no match for them. And I said, that's one way to look at it. I said, another way to look at it is that all I have to do is win one case. Because if I win one case, it's going to scare the hell out of all of you, and you'll end up settling with me. Every one of the cases on terms that are favorable to us. And I'll never forget him saying to me, well, Richard, I also dream of being center for the Los Angeles Lakers, but that's not going to happen either. And so I've always dreamed of one day sending him a picture of the Lakers team with a face cut out. So Dimensions Films was, in fact, the first case. It's a long-winded way of answering your question, how it arose. And, in fact, we lost that in the district court. Mm-hmm. And we lost it on the grounds that the court found that you could not determine whether it was a copy of Get Off Your Ass and Jam, which was the song, and it was a chord, and it was copied. And even if it was copied, which they admitted, it was so beat up and torn up and reversed and switched around, you would never know it was a George Clinton song. So that was demoralizing. But I came up with an idea on appeal. And the way we won that case on appeal was, there's a separate statute on sound recordings. And and I'm doing this from memory now, but what the sound recording statute says is that the copyright owner of a sound recording, and by the way, to back up, when the sound recording statute was enacted, it was a trade-off. On the one hand, it would not be infringement for someone to cover someone else's song, right? But then so the sound recording owner would not have any kind of claim if there was a cover.
Other than to the statutory.
Right, other than statutory for a compulsory license. But the actual sound recording owner, the composition owner would have rights in the new composition of a cover. Sound recording owner, you could cover it and not commit infringement. With respect to the sound recording, however, the protection was, the statute says that the sound recording owner has the exclusive right to rearrange, adapt, cut it up, do everything with it, and that there's language about it that a sound recording, the sound recording owner has the ownership of the entirety of all of the sounds, and that someone creating a sound recording that consists entirely of new sounds does not commit copyright infringement. So we made the argument that consists entirely of new sounds means that if you even use a second of a sound that came from the sound recording under the statute, it's copyright infringement. And the Sixth Circuit bought that.
Right, and so that was effectively the end of the de minimis argument for sampling, right, and established this per se rule that if you use anything, however short, as a sample as opposed to recreating it yourself, you're going to find copyright infringement. I have to ask you now, let's compare this with your latest case here, the VMG Sal Soul versus Madonna, where the Ninth Circuit has seen fit to depart from the Sixth Circuit's per se rule on sampling. And now what are you arguing?
So what I basically argued in that case was that I was insane when I argued the other way in the Dimension Films case. So no, I didn't argue that. But
it's an effective argument.
I represent. So the facts of that case are outrageous, by the way. I represent Shep Pettibone, who is the producer of Madonna's song Vogue, and he had an assistant. He had an assistant when he created the song Vogue, who was an assistant engineer with him. Well, later that assistant ended up becoming a businessman, and he bought the Sal Soul catalog in like 2008 or 9 with the intention of going back and suing Shep for copyright infringement, even though he worked on the song as the engineer, because he believed that Shep had sampled one of Shep's own earlier songs that he worked on and produced that was from the Sal Soul catalog. But in any event, what we argued basically was that the Sixth Circuit had not followed Bridgeport, and the Ninth Circuit had not followed Bridgeport, that the other circuits since the Bridgeport Dimension Films case had stayed with the conventional copyright infringement analysis, and then under the traditional copyright infringement analysis, the 1 second horn hit, less than 1 second actually, was de minimis, and it was not original, and it was not copyrightable, and the Ninth Circuit agreed, although there was a dissent in which the Ninth Circuit, one person in dissent said we should just follow Bridgeport. So if this does go to the Supreme Court, I may argue both sides.
Well, that was my next question. So should this end up going to the Supreme Court, we could only hope. Which side will you argue for?
Oh, that's an interesting question. I don't know. That's a good one. I'll have to think about that one.
We'll come back to it.
Okay.
A couple more, just I want to address before we get into some of the other questions that I know we've been bringing up in class. The Bridgeport versus Universal case about sampling from Biggie's Ready to Die.
Oh, that's
I raised this because at $4.4 million, it's probably your second largest verdict to date. Maybe the biggest till the latest in Blurred Lines. What did you see as the biggest challenge posed by that case? What did you think of the outcome?
Well, it was great. So this is a case for all you lawyers and law students that teaches you a lesson about over litigating your case. So this was a sample. It was clearly a sample of an Ohio Players song, Singing in the Morning. And we had a claim on the composition and on the sound recording. So under federal copyright law, you cannot get punitive damages for a copyright infringement claim. And you may not know this, or you may know this, that federal protection under federal copyright law on sound recordings only exists for sound recordings first fixed on a master recording after February 15th of 1972. So if you have a sound recording that's allegedly infringed and it has to have a federal copyright law claim, that sound recording has to be first fixed on a master on or after February 15th, 1972. So the Ohio Players song, we believe, was released in March or April of 1972. Well, halfway through this case, I got a letter from my opponent, and it said, "We've been to the library, okay, and we have searched microfiche." Back when this was 2004, remember? So you didn't have what you have now. We searched microfiche, and we found this newspaper article, and it shows that "Singing in the Morning" was first released on February 4th, 1972. Therefore, your federal copyright law infringement claim on the sound recording of "Singing in the Morning" is frivolous, and you better dismiss it right away, or we're going to move for Rule 11 sanctions against you. To which I said, "Thank you, sir, because even though you don't have a federal copyright law claim now for Singing in the Morning's master, guess what you do have? State law claims for a sound recording released prior to February 15, 1972. The federal copyright law claim would not be preempted, so you could file a state law claim for conversion, for unfair competition, for common law copyright infringement. And guess what that claim comes with? Punitive damages. And so guess what we got? A punitive damage award of $3.6 million in the case that I never would have gotten if my opponent had not told me that I had no federal copyright law claim. So
Don't work too hard.
Don't work too hard, and think about what you're doing. Now, also, and this kind of plays in with the Farrell and the Robin Thicke deposition transcript, which I used to, I think, great effect in the Blurred Lines trial. In that case, just as a bit of perhaps comic relief, Sean Diddy Combs was deposed in that case. And even though it was a clear sample, I am betting, I don't know this for certain because I was not included in the conversations, but I'm betting that someone before his deposition told him, don't admit anything. I'm betting someone said don't admit anything because I videotaped the deposition, and when I asked him when he founded Bad Boy Records, he said he'd never heard of Bad Boy Records. And he didn't know what I was talking about. And when I asked him whether this was a sample, he says he's not qualified to answer whether it was a sample. And when I asked him I said, but you're Sean Diddy Combs, you're the producer of all these songs, you're you. You're telling me, he goes, well, I'm not the producer, so I can't tell you whether it's a sample or not. To which I said, okay, fine. And I played the music and I said, okay, do the samples sound like, and they were identical. It was an identical sample. And he said, in a videotape deposition, I'm not qualified to answer that question. And you're not qualified to answer whether the two songs sound alike, whether these two samples sound alike. And he said no. So that's the way you walk into a $3.6 million punitive damage award in a copyright infringement case.
Good story. So let's talk about the Atomic Dog case with
Okay.
Bridgeport and A&M Records. We played the sample in class recently. This is concerning the compositional...
Not a sample, though. It's a replay.
Compositional copying
right.
of Atomic Dog, where the Sixth Circuit actually found infringement for use of the word dog.
Yes.
In the same sense in which it was used in the original.
Yes.
Right? So how did you come up with the strategy to... I would think that many of my students, even at this point, would think a single word, right? We're not going to go after a single word, but you did.
I did. So maybe I was young and stupid back then. I don't know. But I was, the way we approached it was that if you listen to the two songs, and my musicologist, who was our expert in that case, concurred with this, but I had the idea that that the word dog ended the verse, each verse of, I think the song was Dog in Me, in the same way that it ended each verse in Atomic Dog. So it's the use, so for originality, the concept of originality is, it's a very low threshold, right? So if it's used in a unique way, it can be compositionally similar, even if the word itself is not original and you have no ownership of it. So our argument was that it was used as musical punctuation in a unique way at the end of each verse. Now, and we won on that. But we also had the bow wow wow, yippee yo, yippee yay use as well, and some other things. So had it just been the dog and not the other elements, I'm not sure what would have happened, whether we would have brought it, whether we would not have brought it. But it was part of several things that we claimed were infringing within the song. And we came up with this theory of musical punctuation and the use of the word compositionally in the same way it was used in the original song.
Which I think goes to highlight something that, I know we've been talking about quite a bit in class, which is that a lot of these cases, in copyright infringement in particular, are going to be highly contextual, right? It's going to depend on the specific facts, which we're going to get into in a minute to compare. And I think which helps to put into focus a bit sort of what the implications of these cases are. And I'd like to move to that next, but one last case I just want to throw out in the mix before we talk about this, and maybe we can actually ask you what you feel like the implications have been. But there were a series of cases you did with Eminem. There was
Yes.
the Aftermath case interpreting a contract between the labels and the digital platforms as a license, which would effectively then pay Eminem 50%. And then with 8 Mile Style, Eminem's publisher and Apple Records settled for digital licensing on the publishing side. And both of those were important as digital was introduced to the world in terms of letting artists and songwriters know what they're going to get paid for the digital sales of both their sound recordings and their compositions. What do you think? How have you seen things change since those verdicts?
The Apple one is an interesting one that you, with your background at Universal, may find really interesting. Let me speak. That one settled right before the verdict, right before there was a verdict at trial. But it's an interesting case, and one that I think you might find that it's still cutting edge in some ways. So in that case, there was so do you all know what a controlled composition clause is? Everybody know what a controlled? So when a artist signs a record deal, generally speaking, there's a clause in the record deal that is called a controlled composition clause, which says that the record label has the right, is getting, together with the sound recording, a license for the compositions that are written by the artist. So they don't have to go out and get a separate, what's called mechanical license, which is a license for publishing, okay? So it's a controlled composition clause. In the M&M contract, it said, we will license. That's the phraseology that was used. It didn't say we hereby license, which we made a big deal about. But even if it had said we hereby license. So we said that remember, this is shortly after iTunes launched. And there really was, my client was concerned about the visibility. They had no direct relationship with Apple. They had no idea to know whether Apple was accounting to them properly. They had no communications with Apple. They had to rely entirely on Universal to tell them when Apple was reporting, and they weren't giving them access to the information. So that really upset my client, who's Eminem's publisher, and we ended up suing Apple for copyright infringement, for the fact that they had not gotten a digital license from them to exploit the compositions digitally. And one of the arguments in the case was that there's something called a pass-through license, where a record label who has a controlled composition clause in their contract can pass through to a digital provider the right to exploit the composition when it licenses the sound recording. But we argued, and still I don't think really has been resolved, that that pass-through license does not apply to digital licensing for a lot of different reasons, because there's no such thing as caps where you cap the number of compositions for which you get a royalty. There's no reduced statutory rate that's allowable, things of that nature. So we had an argument that even if there was a controlled composition clause and they didn't have to get a separate license, which we said was not true because of the we will license instead of we hereby license language, that they didn't have the pass-through license to pass through to Apple anyways. And so we were litigating this case. We were in the middle of the trial, and I had an idea during this trial, and the idea was that at the time, Eminem in 2006, 2005, his downloads on iTunes represented around 1% of all downloads. And we viewed iTunes as a loss leader. That Apple just has iTunes to do what? Sell iPods back in the day, really before the iPhone, when they were selling iPods. And it was really a mechanism to sell iPods. So I came up with this idea that we should say that the profits attributable to Apple for the infringement included iPod profits. And they moved to dismiss that, and when the judge denied that and was going to let that go to trial, they settled.
Smart.
So that issue was a really complicated but a fun case and a good case, and I kind of wish it would have gone to a final judgment, but it didn't. The FBT case, and by the way, how I got involved with Eminem is when iTunes launched, record labels, and we believe conspiratorially, got together and decided that they were going to treat iTunes sales as resales, just like when Best Buy sells a record that's distributed by a record label, or when there was Tower Records, they sold it. It was a resale of the sale so that the artist got a low royalty rate, because in a record contract, artists get paid one of two ways. If a record label sells a record, right, there's a low constructed retail price royalty. But where a record label licenses the master to a third party, think of a compilation album, think of a TV show, think of a movie, there's a provision that says on licenses of masters, we split net receipts 50-50.
It's a much higher percentage for the artist.
50-50 as opposed to maybe 10% of the retail price. And so that's huge. And so record labels, recognizing where this industry was going, we think got together and said, we got to treat these iTunes sales as sales instead of licensed income. And Eminem said, no. And the people that ran FBT, which was his record label that furnished the services to Interscope and Aftermath, and who share in the master royalties, said no. And they told the owner of Bridgeport Music and Westbound Records that they were thinking about doing this, and he said to them, you got to go down to Nashville and meet Richard Bush. He won these cases for me for Bridgeport. He should be the one handling this for you. So again, it goes back to my taxi cab ride, and that I would never have done that either had that not happened. Exactly. And
Aftermath was a big deal. I was there at the time. And
yes, it was a big deal. And we won that case in the Ninth Circuit, where the court said, and Peter Manel, who's speaking here, helped us in that case instrumentally. He was one of our experts in that case. And we won that case in the Ninth Circuit, and on the fact that the licensing language was clear, and it was a license, not a sale. And from that, we represented numerous artists with same claims, and there were class actions launched, and probably our decision in that case and the victory ended up costing the record labels, I would say, probably $1 billion is not an exaggeration based on the class actions that followed and the lawsuits that I was involved with as well.
And changed the way that we handle digital licensing, or we handled digital licensing going forward for sure. So I'll take that to make this transition to the other idea I wanted to talk about how fact-specific these cases can be. We've been seeing more substantial similarity-based cases in music law lately. And it's important to emphasize that not all the cases are alike, and that the facts can really impact the approach and the outcome here. The track involved in Blurred Lines, for example, is unique in that it was registered in 1977, thereby just missing the 1978 cutoff for the protection of sound recordings, which may affect the implications for how broad the holding might at first appear. And I know that you're currently working on the latest Ed Sheeran case, which some of you may have heard about, with the songwriters behind Matt Candle's Amazing. How do the facts of that case differ from Blurred Lines, and how do you think that those differences are affecting your approach there?
So that's another very interesting case. It's actually not Matt Cardle's Amazing. So here, again, an interesting bit of copyright law for everybody. My clients, Martin Harrington and Thomas Leonard, they wrote a song called Amazing. And they created this beautiful chorus in their song Amazing. And then Matt Cardle, who won the X Factor in the UK, licensed that chorus, and he used it in his song called Amazing also. But because there's nothing original from Matt Cardle's Amazing that was copied in Photograph, Ed Sheeran's Photograph, Matt Cardle and the other writers of that Amazing have no claim. In order to have a claim, the only claim is the claim made by the original writers whose chorus was used in Amazing. So when someone creates a derivative work, just a bit of maybe useless, maybe useful copyright law, the owner of the derivative work only has ownership of new original material that's included in the derivative work, and not anything that was from the original pre-existing work. In this case, there are 39 identical notes in a 50-note chorus, and that or 60-note chorus, and if you play it, it's identical note for note, pitch, duration, etc. And it is a textbook, what one might consider to be a textbook copyright infringement claim. Yeah, so if that answers your question. As far our approach to that, and there are a lot of ways to handle these things, and there's a lot of unique things you have to think about. So one of the things that we have done, for example, in that case, or we will do, is I have spoken to like MIT mathematicians. So if they're to claim that it was independent creation, I am going to have an MIT mathematician identify what the probability is that you would have 39 identical notes, pitch, duration, everything, in a chorus made up of something less, a little bit more than that, given the mathematical probabilities, and it's going to be astronomical. So that's one way that, in a case like that, to really deal with issues of that kind. And so that's
an example of a rare intersection with law and math.
Yes, exactly.
Right.
So then there are different ways that you have to think about how to. So you always have to think about how you're going to prove your case, how you're going to deal with different issues, and that's how we, I think, succeeded in the Blurred Lines case as well. Is that we, quite frankly, outthought our opponents.
What do you see as the biggest challenge in these types of cases, the substantial similarity cases?
There are, in hindsight, everything looks easy. Sometimes, now that I look back on these victories and we talk about them, it all sounds so easy, or it sounds like, oh, okay, you won. The amount of work that is required to win these cases is, every time I do one, I think to myself, I'm never doing this again. And then like a month or two later, I'm thinking, all right, what's the next one? But when I'm in it and when I'm doing it, I think I never want to do this again, because the amount of work and thought and pressure is enormous. So what was your exact question?
The biggest challenge.
The biggest challenge. The biggest challenge is, there's so many challenges. Okay, so for example, let me tell you this challenge. Try this one on for size. After the court ruled that Marvin Gaye's recording in Blurred Lines could not be played at the trial, it was at the pretrial conference right before trial. And so I'm left having to try a copyright infringement claim involving a song where I can't play the song after going through a year and a half of litigation. My opponent calls me up that night, and he says, Richard, you've got to settle this case, because let me tell you what's going to happen. He said, you can't win this now. You can't play Got to Give It Up at the trial. So how can you win? And let me tell you what's going to happen. You're going to lose. And if you don't settle, the judge is going to find your continued prosecution of the case in light of this unreasonable. And we're going to move for attorney's fees. And we've got about $2 million or more in attorney's fees. And we're going to get those attorney's fees. And the gay family, we know they're not wealthy. They live off their royalties from BMI or ASCAP, or whatever their public performance royalties are, or their EMI royalties. We'll garnish those royalties. They won't have any money to live on. And they'll be destitute. They'll be on the street. And it's going to be your fault because you didn't talk sense into them to settle the case. That was a challenge.
Yes.
And I called Jan Gay up on the phone that night, and Marvin's former wife. And I relayed the conversation to her word for word. And I said, it's up to you. And I gave her some advice that I'm not going to repeat, but she said, let me think about it. And she called me back with Nona, her daughter, on the phone later that night, and she said, Richard, I believe in you. I think you can win this thing. I know you can win this thing. We're going forward. That's a challenge.
Yeah.
After I went back to my hotel room, I laid on the couch and I put a cold compress on my forehead. I figured that I needed to figure out how to win the case. That was a challenge.
Yeah.
But we won.
That's right.
So when you ask me what the challenges are in these cases, you know, it's really easy to sit in a law school and talk about the legal issues, but litigation is as close to warfare without actually shooting people up that you can get. The stakes are high. Mm-hmm. And when attorney's fees and costs can be imposed and you're dealing with clients who don't have that much money and who face severe consequences if they don't win, I take that responsibility very seriously. And I personally get involved with these cases. And the challenge and the enormity of the situation is not lost on me at any point in this. So the challenge is figuring out how to win, putting the case together, financing the case sometimes, and then the pressure of needing to win in order to make sure your clients are okay.
Sure. Yeah.
The challenges are as broad as the universe because it runs the gambit from the legal issues to the very personal issues, right, and everything in between.
And I think that the personal and interpersonal issues that can arise with this type of litigation are part of what make it so interesting, as we will undoubtedly get into in the panels today. Part of, I think, a lot of the attention that the Blurred Lines case has gotten is the perceived tension in this so-called artist versus artist litigation, right? There's some in the industry who are thrilled with the direction that Blurred Lines may be taking things in terms of licensing and attribution. Others are concerned that if taken too far, fear litigation could squash creativity. Some artists may be too afraid to sound like someone else. Do you think that these concerns are valid? Do you think about this in the pursuit of these sorts of cases?
I don't think that the concern is valid. I think it's overblown. So 10 or 15 years ago, there was it's actually 15 years ago now at least, a case called Three Boys Music, which involved the Isley Brothers and Michael Bolton. And that case, too, had the same so-called outcry after it because it involved the same issue of kind of a constellation of elements. There were 5 different elements that were allegedly copied, and there was a finding of copyright infringement. But it did not, in my view, is far weaker than the Blurred Lines case, and it did not stifle anything. There are, this case, as you said, copyright infringement cases are decided by the facts of their case. And we had identified so many different compositional similarities that I do not buy into this, the sky is falling. People will not be allowed to whistle anymore, and there'll be no humming in the streets. I don't buy into that. and I don't think it's stifling anything. In fact, I think it's had a positive effect. So, there's the Sam Smith, Tom Petty issue, where Sam Smith created a song, Tom Petty thought it copied his, and they resolved it. And, there are not these, in my view, significantly additional cases that have been filed since then that change anything. I think the standards of copyright infringement are the same. Those standards were applied in this case, and we won. And there are a lot of facts. My opponents, and I'll discuss this when we have our panel next, or whoever wants to discuss with me, like to talk about how this was a case about concept and feel, and it's not. And we have plenty of people who are on our side. I know there are people on the other side, but there are plenty of people who are on our side that agree with our position. It is the copying of compositional elements. There was an intention to copy it. We showed that. We showed admissions by Pharrell Williams that were contradictory to what his statements were in his deposition. We showed admissions by Robin Thicke. We showed admissions by Universal's own internal people who recognized what this was. And that's what people don't see and hear. They don't get to see the actual evidence. They just hear people commenting on it without knowing what actually was discussed at the trial. And that's a shame, but that's what has happened in my view.
One point of particular interest for students, I think, is whether and how holdings like the ones that we get from Blurred Lines might differentially impact urban music. In the Blurred Lines case, both the original composition, Got to Give It Up, and the infringing composition, Blurred Lines, fell to lead sheets, right? Which is to say that they didn't have traditional sheet music. Do you think that music that tends to fall to lead sheets is more susceptible to this type of litigation?
Okay, so this is the issue that is really concerning, that the decision that was made by the judge in the Blurred Lines case that people I don't think understand or realize. So prior to 1978, when one was going to file a copyright registration with the Copyright Office, you could not file the recording as the composition. You have to file what's called deposit copy, okay? But you couldn't file the recording as the composition. After 1978, sometime after 1978, the Copyright Office, recognizing that modern music is created in a studio, and that the recording is the best example of the full composition, allows you now to deposit the recording as the composition. But prior to 1978, you couldn't do that. You had to file a written notation. And most of the things that were deposited were just sketchy lead sheets. That was not a full transcription of all that was in the composition. So in this case, Marvin Gaye's song, Got to Give It Up, was first released in 1977. He created in the studio. There was no written sheet music. People don't sit there and write sheet music out anymore. And so he recorded in the studio, and someone came along after to get the copyright file and put together just a lead sheet with a sketchy lead sheet just to get it on file. Well, the judge ruled that because that was what was published, that written lead sheet, that our claim was limited to only the elements reflected in that lead sheet. So overnight, our case went from 14 or 13 different elements that we said were copied down to like 5. And so think about the impact of that decision. If that were, and by the way, in the Taurus case involving Led Zeppelin's Stairway to Heaven, everyone knows that Taurus lost. What they don't know is that the judge followed the Blurred Lines decision and said that they could not play and so by the way, in Blurred Lines, that was why the Marvin Gaye song was not allowed to be played, because the court said to play it would be to expose the jury to elements that are beyond what's in the lead sheet, so therefore be prejudicial. Even though neither Pharrell nor Robin Thicke can read sheet music and certainly didn't sit there and look at a lead sheet when they copied, when they copied the song, that's what he ruled.
Although Robin did have to play from the lead sheet at one point, right?
Well, he played from something that he, so that's something else we'll talk about. But think about the impact. So in the Taurus case, going back to that, what people don't realize is what the judge made the plaintiff do in that case was not play the intro that was at issue from the recording, but rather replay the lead sheet. And whoever created the lead sheet of the Taurus song was probably high on Vicodin and drunk on vodka like Robin when he gave his interviews, as he said, and it sounded nothing like the recorded composition. So you were playing something in an alternate universe that no one had ever heard before, a lead sheet, and comparing it to the Led Zeppelin song. So of course they lost. And by the way, in our case, my opponent had their musicologist recreate her interpretation of the lead sheet and play that, which I called a Frankenstein-like monster during the trial, because it was just this recreated thing that no one had ever heard before. And you're saying that's got to give it up. And so it's insane. So now we have two different types of copyright infringement trials. One for songs that are infringed after 1978, where you can actually play the recorded composition and have a real trial. Or if it's a song that was created before 1978, then you have a completely different trial, and it's only the lead sheet can be played and the recording cannot, if this ruling is allowed to stand. And think about the other implications. If you're, and I put this in one of our papers, if you're a clever infringer, what do? Go to the Copyright Office now and take a look at every lead sheet on file for the Beatles, the Rolling Stones, and Marvin, and everyone else that wrote a song before 1978, and any element not reflected you can copy with complete immunity? Is that where we're at? It makes absolutely zero sense, and that ruling, in my view, cannot stand. And it also disenfranchises these incredible writers of music. So now, who's the writer? Is Marvin the writer of his song, or some guy who's unknown who came along and chose to transcribe some notes? He's the writer? He's the effective author of these songs, the transcriber? That's the rule?
Should we apply a different standard for music that's not traditionally notated, for music that falls to a lead sheet? Should we?
Well, there's a terrific amicus brief that was written by supporting us that I encourage you all to read. So, written by Sean O'Connor from the University of Washington Law School, Latif Tima, and Stephen Jamar from Howard University with the Institute for Intellectual Property and Social Justice. They wrote a terrific amicus brief that was signed on to by numerous law professors and some of the greatest songwriters of the 20th century, supporting not only the decision, but also discussing why the court's ruling on this lead sheet is not supported by the 1909 Copyright Act and should not be allowed to stand. It's pretty complex, but it's a terrific brief, and I would encourage you to review it.
And we'll talk further about what this might mean for differential treatment in different genres of music, but I think that's one of the biggest impacts outside of regular copyright infringement that stem from this case. So in our little bit of time remaining, I'd ask you, what do you think is next? What do you predict as future areas for discord and clarification in copyright law?
There's always going to be room for discord because, I'm sure in the next panel you're going to have people that disagree with what I've said, disagree with the decision. This is not like, a Fox News debate where we're going to be yelling at each other because everyone's entitled to their opinion. This is not, here's the thing that I would say, this is not science, it's art, okay? And so whenever you have a judge or a jury making a decision, remember, the judge sustained this verdict and said there was substantial evidence to support this verdict. It wasn't just the jury. The judge, there's a two-step process. You have to get past the judge on the compositional similarities before you get to the jury. And we did that, and then he sustained the decision after. So when you talk about what's next and where future areas of discord may be, there's always going to be differences of opinion about whether something is genre or whether something sounds the same or whether something is compositionally similar. But again, I go back to the same thing I said before. This decision and the overall discussion that people are having over this decision, I think is overblown. I think this is the law is the same, the elements are the same, and how you prove substantial similarity is the same. And there's a great case in the Ninth Circuit called Swirsky that everyone should read, because people are under the misimpression that copyright infringement is just the copying of specific notes in a row, or there has to be some number of notes that constitute copyright infringement. The Ninth Circuit in Swirsky, which was addressed in Three Boys as well, talks about all of the different elements that make up a composition and how there's no magical formula to what constitutes copyright infringement. And if you can show, through expert testimony or otherwise, substantial misappropriation of elements that are part of a compositional analysis, you've established your claim and it goes to the jury. And so there's always going to be disagreement and there's always going to be discord, but that's part of what, makes up the law, and I think trials of this nature.
Yeah, certainly makes copyright interesting. So I know that the appeals briefs have been filed.
So all the appeals briefs, the first round has been filed. So my opponents filed their brief, and they filed, and there were 2 amicus briefs filed on their behalf by musicologists and others. I'm not going to say they were songwriters because they actually, a lot of them weren't, even though they were called songwriters in the amicus brief. And many of them were actually, as we have investigated, clients of my opponent's law firm. They were artists that had been signed to the defendant record label. They were business people in the industry. There were a whole host of different types of people that signed onto that amicus brief. And we then filed our own amicus brief. We filed our brief, and then there were 2 amicus briefs filed supporting us. 18 different musicologists from around the world, literally, filed an amicus brief supporting us. And as I said, a large number of law professors and songwriters, some of the greatest songwriters of the 20th century, filed an amicus brief supporting our side. And now we are waiting on the other side's reply brief, and then we get the last word, and then it will be set for argument.
In the fall.
With the Ninth Circuit, you never know.
Of
they are backed up. I mean, it could be the fall. It could be this time next year. Who knows?
Right. All right. Well, with that, we'll take a quick break and come back, and we'll start off by asking our artist panelists their impressions, and we'll welcome you back for the first panel as well.
Thank you very much.
See you in 15 minutes.